Mr. Deputy Speaker.
Order.
Item 2, resumption of debate on the Criminal Law Reform Bill, second reading.
Associate Professor Walter Theseira.
Mr. Deputy Speaker, I welcome the extensive revisions in the Criminal Law Reform Bill. The careful consultation process that led to this bill started with the formation of the Penal Code Review Committee in July 2016 and culminated in extensive public engagements after publication of the PCRC report in September 2018. This should be a model that any complex, far-reaching legislation should follow. I will speak on the relationship between the law and society. Sir, this bill is necessary because social standards change over time, and yet the law evolves only when statutes are changed or when precedent is set. We no longer believe today that marriage implies the automatic consent of a spouse to sexual relations. It is right that this bill repeals the marital rape immunity. But the law may also shape society. If laws are not properly limited and implemented, the law may have significant unintended and adverse effects on social behavior. Less recognized is the fact that social standards also give the law effect. Without a shared consensus around the justness of the law, victims will hesitate to seek justice and offenders will be emboldened. My concern on the unintended adverse effects of the law relate to this bill's enhanced protection for vulnerable persons. This bill enhances criminal law around offences against vulnerable persons in line with recent reforms such as the Vulnerable Adults Act 2018. This is important because in our aging society, the number of vulnerable elderly will increase significantly in the coming years. It is right that the bill expands protection for such vulnerable adults by making it clear in the new Section 304B of the Penal Code that neglect and abuse leading to the death of a vulnerable adult is a serious offence. Section 304C further provides that persons in the same household have a duty of care to stop such neglect or abuse. Sections 335A and 335B make similar provisions for abuse and acts that endanger life or personal safety. In last year's debate on the Vulnerable Adults Act, many members spoke on how vulnerable adults need the protection of the law. I will not reiterate those arguments. What I want to clarify is how these increased protections in criminal law will sit with the rights of the vulnerable elderly to choose how to live out their days in the manner they consider the best. In the book Being Mortal, American surgeon Atul Gawande reflects on the excessive focus that modern medicine places on prolonging life rather than on ensuring a high quality of life. Medical interventions towards the end of life often cause great harm to the dignity or autonomy of patients. The patient must trade the comforts of home for endless nights and days in the intensive care unit. The patient must endure becoming dependent on others for every little aspect of daily living. The additional days or even weeks of life in this state are not always considered worthwhile. Given these trade-offs, many among the elderly, when faced with a medical emergency or a serious illness, may wish to avoid treatment. They will expect their families to interpret and act on their wishes. I want to be clear, I'm not discussing euthanasia. While I agree with this bill's proposal to decriminalize attempted suicide, I think society is rightfully more cautious on the matter of abetting suicide, which is what euthanasia is in practice. These are still very serious offences under the Penal Code. But there are a wide range of practices at the end of life which are not euthanasia in the ordinary sense. Some practices are widely accepted, such as choosing to refuse resuscitation or artificial life support. These are codified in the Advanced Medical Directive Act. Others are more controversial, such as refusing nutrition, medication, or medical advice and treatment. Consider some examples of decisions made by persons near the end of life. End-stage renal failure patients may choose to stop dialysis. Patients of cancers and other diseases addressable through medical interventions often refuse treatment. The elderly may wish to stay at home instead of going to the hospital when their health deteriorates significantly. Former US President George H.W. Bush, at the end of his life, informed his staff he did not want to return to hospital, and as a result, he passed on peacefully at home. Mr. Deputy Speaker, which practices may be caught under the law as neglect by the family, leading to the death of the vulnerable adult? What makes an otherwise accepted practice neglectful, given that there will be concerns about the mental capacity of vulnerable adults and their physical inability to seek treatment without the support of their family? Which practices do we want to prescribe in the law? Sir, the law is like Chekhov's gun. If the law is written in the first chapter, then we can expect it will be used in the next. Consider some concrete examples. Family members may disagree on the appropriate medical intervention for a gravely ill, vulnerable adult. And if they cannot prevail in the discussion, they may consider involving the law. A gravely ill, vulnerable adult may lose autonomy in their decision to stop treatment because the family is both concerned the adult lacks mental competence and the family fears breaking the law. A healthcare or social work professional may refer a case to the police because they believe the vulnerable adult or their family is refusing treatment so as to constitute neglect. There may be cases where the family does fail in their duty of care. Yet we do not want cases to be referred unnecessarily to the law. The Terry Schiavo case in the United States created a protracted legal battle over the so-called right to die. Mrs. Schiavo was in a persistent vegetative state, and her husband, who was a legal guardian, argued she would have wanted withdrawal of artificial life support. Her parents disagreed. The case was exploited for political purposes and resulted in a 15-year legal battle. A landmark case that determines a particular standard of care required to avoid the charge of neglect at the end of life could have severe impact on the practice of medicine and on the rights of families and the vulnerable elderly. This House has expressed grave concerns about the growing practice of defensive medicine. Given that aggressive medical intervention in the last stage of life is often futile, costly, and harmful to the dignity and autonomy of the patient, we would not want such interventions to become routine simply because of legal precedent or fears by medical professionals or family members about their potential legal liability. So I ask the government to provide clarity. What is expected of the medical treatment of a vulnerable elderly adult near the end of life in the home environment? To what extent can or should the wishes of the vulnerable adult be respected with regards to medical treatment and other acts that affect life? For example, is it neglectful if the family does not convey a gravely ill, vulnerable adult to hospital because of their expressed desire to pass on at home? What if the vulnerable adult wishes to stop routine medication and consultation? How can families assure themselves that their actions are lawful and in furtherance of the vulnerable adult's wishes to live a good life until the end? I note that the Minister for Social and Family Development touched on these issues in the debate on the Vulnerable Adults Act 2018, which also enhanced penalties for offences against vulnerable adults. This bill, however, proposes specific sections of the Penal Code which may affect the autonomy of vulnerable adults and their families in making end-of-life decisions, and so should be addressed separately today. Next, my concern on the social standards that give the law effect are centered on this bill's expanded protection from sexual offences. These revisions include removal of the limited marital immunity defense for rape in Section 375 of the Penal Code and substantive new provisions in Section 376 and 377 on consent, voyeurism, sexual exposure, and child abuse. This is progressive and important. But I fear that enhancing these provisions against sexual offences may be meaningless if we are ultimately hypocrites as a society and we do nothing about the social norms that tolerate such behavior. The experience of many countries in recent years of the #MeToo movement is instructive. In many countries, there are already strict laws against sexual offenses and sexual harassment. Yet, despite decades of actively enforced law, we had the Me Too movement, a grassroots movement by women fighting against sexual harassment as a daily fact of life that women felt they had to accept in order to progress in their chosen careers. The law, in short, was not an effective recourse for many women around the world, nor did the law restrain the behavior of many men. These issues are also present in Singapore. Ms. Monica Bay has bravely highlighted her own experience as a victim of voyeurism, which has shown inadequacies in how her institution handles sexual misconduct cases. After she came forward, other women reported similar experiences. As Ms. Bay posted on Instagram on May 1st, 2019, and I quote, "I hope that Singapore has reflected on what has happened, why this blew up as big as it did, and learn not to avoid issues, but rather face the hard reality. Sexual misconduct and assault is much more prevalent than it appears to be." End quote. Sir, these revisions of the law are just a means to the end. The social objective must be to create the conditions for a society where the law is rarely applied because all segments of society accept that these acts are wrongful and there are strong cultural and social norms against such sexual offenses. The criminal justice system cannot undo the harms caused by a sexual offense. The trauma of an offense will remain with the victim for life. Serious efforts to correct this must start with attempting to understand the actual incidence of sexual offenses and harassment in Singapore, the social conditions around the normalization and perpetration of such offenses among some social circles, and applying the right educational and policy levers to correct these social conditions. Mr. Deputy Speaker, I stand in support of the bill.